Next matter is Shauna Smith.
Hello?
Are you Shauna Smith?
Yes, sir.
Mr. Smith, you are here because a criminal complaint has been filed against you by the Bonneville County Prosecuting Attorney's Office. Have you received a copy of their complaint?
Yes, sir.
Have you had time to read it over?
Yes, sir.
It is a felony charge. Would you like me to go over it with you, or do you feel you understand the nature of the charge?
Would you go over it, please?
Okay, the Prosecuting Attorney's Office of Bonneville County has alleged that you have committed the felony crime of video voyeurism by installing or permitting the use of an imaging device without mutual consent. They allege that you, on or about July 12th, in the county of Bonneville, state of Idaho, did install or permit the use or installation of an imaging device at a place where a person, they don't identify the person other than through an initial, MR, would have reasonably expected privacy. You did this without her knowledge or consent, with the intent of arousing, appealing to, or gratifying your lust or passions or sexual desires. If you're found guilty of this, or if you plead guilty, there could be up to 5 years of prison or a $50,000 fine plus restitution. So those are the allegations. They are allegations. You may or may not agree with them, but do you understand them?
Yes, sir.
Because this is a felony, and because you are in custody, the bond was set by prior court order at $30,000. We are obligated pursuant to law to set your case automatically for what is called a preliminary hearing. That is a special hearing where the state of Idaho, through the Prosecuting Attorney's Office, must prove that you probably committed the allegations of the complaint. If they succeed in proving that, your case is then transferred to district court for further proceedings. And there you would appear before a district judge who would carefully advise you of your rights again, and there you could plead guilty or not guilty. That's called a preliminary hearing. You will be present at that hearing. You will have a right to question witnesses that may be called against you. You also could present a defense if you wanted to.
Okay.
That's called a preliminary hearing. And because you are in custody, that must be set to be heard within 14 days. So what will the date of that be?
July 26th.
Your preliminary hearing is July 26th at 1:30. You have applied for the public defender. I have your application right here.
Okay.
Is everything on your application true and correct to the best of your knowledge?
Yes, sir.
I'll review it at this time. You left blank the lines that indicate what your monthly income is. What is your monthly take-home pay?
I can't answer that without my records that I do not have access to right now.
Well, give me your best estimate. It doesn't have to be exact.
Okay, I work 40 hours a week and make $10 an hour, so that would be, and then 4 days, so that roughly is $1,600 before taxes are taken out.
Per month.
Yes.
Based upon current federal guidelines and state rules and laws, you do qualify for the public defender. So that office is appointed to represent you. Mr. Smith, I presume you saw the video before you were brought into this hearing, is that correct?
Yes.
All right, I think we finished the business of your hearing. Your bond is set at $30,000. You have a public defender. You have a preliminary hearing set on July 26th. And finally, the court is issuing what's called a no-contact order. You're to have no further contact with the alleged victim, known only by initials. You'll receive a copy of this no-contact order. Please read it over carefully. There will be a special hearing on the no-contact order on July 20th, 9:15, to see whether or not the no-contact order should be continued as is, dismissed, or continued with some modifications. In the meantime, you return back to custody, and we finished all of the business of this hearing.
All righty, thank you.